Woods is also on the committee, but he is not in attendance today. All of the other council members are here, along with our legal counsel and our council staff, and with the administration, legal team, as well as chief of staff and executive director of public safety, several members of the media, and the public. So with that, we have a proposed ordinance to basically, it's the body cam footage. So I'm going to ask the sponsor, President Small, as well as the mayor's representative, who is also the sponsor, to take turns and just tell us why we are looking at this ordinance, what it entails, and what the difference would be between what we are currently doing and what this proposal would then set in motion. So President Small, why don't you begin, and then we'll go to Ricardo or you. Okay. The mayor's, the city attorney, Ricardo Woods, will follow Councilman Small.
I'm going to ask Mr. Leonard to go ahead and explain to us exactly the difference of what we have and what's been amended on here for us.
And this is our council attorney, Michael Linder, who will go through the proposal to explain the difference between what we are currently looking at and what this proposal would provide. And then City Attorney Woods can follow, if that's okay. All right.
Thank you. The purpose of this is to make it mandatory upon the City of Mobile when a request to see body cam or dash cam footage, and that's defined in Alabama Code 36-21-210, that when we've been saying stakeholder, that's either the individual themselves or somebody basically authorized to represent them. They are allowed to make a request under state law. And what this ordinance will do is it will make it mandatory upon the city to allow them to see that footage unless it's contrary to other applicable law. In other words, what the state law does is it gives Alabama municipalities or police departments or law enforcement agencies, it gives them the option, but it's actually not mandatory upon them to disclose footage like this. What this would do is it would make it the legislative policy of the City of Mobile that when somebody who is allowed to make such a request makes it, they get the footage unless it is contrary to another law, and they have to be told in writing what law that is. That could be the Grand Jury Secrecy Act. I know we've had a lot of discussion about that, but the Grand Jury Secrecy Act actually does prevent disclosure of things like this while it applies, pendency of an active criminal investigation. If those materials are actually being used actively by the law enforcement agency in a criminal investigation, they shouldn't be disclosed under this or any other proper basis under the laws of Alabama or the United States. But what this does means is that it's the root policy of the city that such footage will be disclosed to people who are entitled to ask for it. And that if it is not disclosed, they have to be given the legal reason, not just we don't feel like it. They have to be given the legal reason why that footage isn't being disclosed. That would give them presumably the opportunity to challenge it in court if the reason weren't adequate, or at least would give them some idea of when it might actually be available to view to them. And then once the legal impediment had been removed, they would be allowed to see it. Now, the state law, in my view, governs all public disclosure of any kind of police footage like this. It has been said there's some ambiguity in the statute, and there is some ambiguity, but I think if you read the whole thing, it's pretty clear that this is the procedure the state legislature has put out for individuals or other people to make a request to view the footage. They are not actually allowed to take a copy of it away either, which is one reason why I opt towards this makes it somewhat legally problematic to actually just publicly release any footage without at least some policy in place to do it. We also have city ordinances in place that makes what's called non-conviction data. In other words, data or materials in police files. Those actually can't be released to anyone except people listed in an enumerated list in the city code. Now, that can be changed by the council. And that's a little bit outside the scope of what we're doing right here. But as it stands right now, footage like this can't even outside of the state law be released, although, again, the council could change that. I think that's a pretty fair summation of where we are with this.
Ricardo?
So not only do I agree with Mr. Lender's recitation of what this says, but it complies with state law. It complies with the current ordinances that we have on the books, and it complies with Zogby. And so it's very narrowly tailored, but it gives us a policy that gives us more insight at the local level, and it conveys a right on our citizens without disregarding all of the privacy concerns that come along with dealing with non-evidentiary disclosures that don't have it with a criminal eviction. So there's a certain aspect that this not only allows disclosure to the people who are stakeholders, but it protects the innocent. And that's really important overall in the balance of everything that we do, protecting the integrity of investigations, but more so protecting victims. And that is why, in large part, you don't have a public records disclosure of body cam. But the mayor has decided, of course, to co-sponsor this because it allows us a lens into some of the problems that we've had, and it still makes sure that we are giving people the legal reasons for not disclosing the information. And so there's an added layer of disclosure there for us that complies with state law and our current ordinances.
Okay. That was fairly short. As we're going forward, Michael, if you would just go back over what we are currently doing, and you may need to get the administration involved too, what we are doing now, as opposed to, what this then will provide, because there's been so many questions about body cam footage. Should it be provided to the public? So what are we currently doing or not doing?
Oh, I want to add, and I think Councilman Carroll specifically requested this as well. But and I've discussed this with the city attorney, and there's still a little discussion to do on this. But we are thinking about there's a possible proposal to amend this proposal to add in that the city will wait a certain period of time before actually submitting body cam footage that would be subject to this to the district attorney or the grand jury process, so that families or stakeholders would have a period of time before grand jury secrecy came down on this stuff to actually view the footage. So that's not in the ordinance as it stands, but I'm ready with when Councilman Carroll requests or after discussion with any of you to modify to potentially put some provision in like that. And I've forgotten your question now.
Well, I was just to go back over where we are
Right.
currently.
Right. So again, by city ordinance, practically any of this body cam footage would be considered non-conviction data or non-conviction materials and cannot be disclosed except to other law enforcement agencies. It can be disclosed to the city council. That is not mandatory. The administration, as our current statutes have it, can hold it back, but there's in fact, let me see. Just 1 second. Chapter 46. Sorry, I had it up and then I looked at something else. There we go. Section 46-45 of the current city code, the police department is hereby authorized to disseminate non-conviction data. Again, that means any file materials that aren't the vital statistics on a conviction. Person X was convicted of crime Y on date Z in court A. But what the current city code on this reads, and again, this can be changed by the council. The police department is hereby authorized to disseminate non-conviction data to the following individuals and agencies and to no other person, corporation, agency, or individual. 1, criminal justice agencies for the purpose of basically criminal investigations. 2, individuals and agencies authorized by statute, ordinance, executive order, or court rule. So basically, there's another law that says it can be disclosed to them. 3, individuals and agencies pursuant to a specific agreement with the police department to provide services. Basically, if there's a separate contractor agreement with the city or the police department to provide the data for a legitimate purpose. 4, individuals and agencies for the express purpose of research, evaluative, or statistical activities pursuant to an agreement with the police department. It's a similar provision. Number 5, the Revenue Department pursuant to paragraph 2 for the purposes of crime prevention and the issuance of city licenses. Number 6, the city attorney and all assistant city attorneys for the purposes of crime prevention, administration of justice, defense or prosecution of civil or criminal cases, and so on and so forth. Number 7, the mayor and the elected council members of the city for again, similar purposes. The fire chief for certain purposes related to fire investigations, and the county director of personnel for purposes of hiring, firing, promotion, demotion. So again, under the current city code, it is illegal to disseminate this just broadly to the public. There are certain classes of people that do have the right to see this, not the right, they have the option to see this footage at the administration's behest, and that includes the council and the mayor. All of you are authorized to view it, not necessarily entitled. That's where city law stands on it. Again, what the state law does is lay out a procedure where the person themselves, or what we've been calling a stakeholder, which could be their attorney, or it could be their next of kin, could be a court-appointed guardian, something like that, they have the opportunity to view the footage, but not take a copy of it away. And that statute is pretty new. There's no law interpreting it. I agree there are some ambiguities in the state statute, but I think it would be dangerous to interpret it as anything other than this is the state authorized method for dissemination of this type of footage. Again, though, it can also be read to say we might possibly be able to release them under other circumstances. We would have to draft city legislation for that, and there would be some issues with it.
Okay, all right. President Small, since this is an ordinance you're sponsoring, would you like to say anything else about it? Any other details?
Yeah, I mean, I'm pretty much glad to present this, and I appreciate the attorney and also the city attorney for weighing in on this. This is something that we needed, and the public has been asking for, and I think we should do as much as we can up under the state law as possible to give the public, what they want. And I have to hear from my colleagues to see, anything that they want to add, to this or et cetera.
All right. Councilman Carroll, since you were on the committee, you first.
Quick question. And this is just going back real quick. Does the council viewing any of the body cam footage before a court date or trial make us witnesses in any kind of way?
I wouldn't think so. The footage is what it is. To be a witness, and I assume you mean in court proceedings, criminal case or civil case or something like that. In general, no, just because you viewed it does not make you a witness, because unless you're the person who actually took the video or has some way of authenticating it, you're just somebody who saw it. I could see it might potentially make you a witness if somebody were alleging that the footage had been altered thereafter and that you had a recollection that what you had seen and what the other people had seen was different, but that would be a pretty rare situation.
Does it put this council in any type of harm from litigation in any type of way or lawsuit?
No, you'd just be viewing footage is the way I would view it there. That being said, I would be careful about what you said about it in public.
Okay. The current language inside the, what year was the original ordinance written? Can you tell me? The one that you were reading from the city?
The one I just
Yes.
summarized. Goodness, it looks... That provision, as near as I can tell, was from 1979.
I've mentioned before that in the late 70s and 80s, there used to be a group that would look at evidence from the city ahead of time so that they could calm or have a bird's eye view as to the extent of the evidence of what happened, so that they could report back to the community, say, hey, this is correct, and the assumption that law enforcement is making to prevent any type of public outcry if the public felt like there was something wrong. Is that type of wording in there for a third-party viewer in the current ordinance that we're trying to change?
Which ordinance are we trying to change?
The wording that we have in the one that's sponsored by CJ and the mayor right now.
No, there's nothing addressing that in there. I will say that the 79 ordinance, as I mentioned, has a couple of provisions regarding individuals or agencies which the police department may have an agreement with, and maybe that get towards what. But I'm not personally familiar.
I want to make sure that that is still there, because I've had several people way older than me tell me that this was done in the past, and we're not taking advantage of that anymore. So I would like to make sure that that provision remains in here, that we need to have that person at times. Mobile is a city that is very slow to react, meaning that we don't get riled up down here and start riots and knocking down windows and stuff like that. But I think that those sections are extremely important, and they need to still be included in whatever changes or adds that we make, to make sure that in the future, if we need a third-party viewer there that can see this and make sure that the decision that was made or the incident that happened or opportunity that happened went down the right path. I want to make sure that that is still there.
Well, that is like I said, there are provisions in the code as it stands, like I said, that allows an agreement with the police department and therefore presumably the city for access to that data for purposes by agreement. That sounds, so maybe there was such an arrangement in the past. I'm just not aware of there being one now.
Well, currently, I'm unaware of anybody that can see this, or anybody that can talk to the public that has the opportunity to view this information, even though these clauses are there. And I've mentioned this to you now 3 times. If there was somebody else that could have seen this ahead of everybody and said, maybe this is right or wrong, it would have helped us along the way to better understand what was going on before we got as far down the road as we did. The other thing is, we talked about timing in the grand jury, in the DA's office. The question is who's asking for the information or the evidence? Is the grand jury asking, or is the DA asking for us, or are we presenting it to them directly ourselves? Because that goes to timing. If they turn around and say the next morning, we want this, then what does that do to our window of time?
Well, I think Mr. Woods can speak more definitively, but my understanding is that, let's say you have a death in custody or something like that, and if the grand jury or the district attorney subpoenas the material the next morning, at that point, that veil of secrecy, if you will, would flow over it, regardless of anything in the city ordinances. But again, if Ricardo wants to address.
So that's right. So any time constraints that we would try to convey to a citizen as a right, it does not limit the authority of the district attorney's office or the grand jury. So Mr. Linder is correct. They could typically, remember, there's an in custody death or a police officer involved shooting. The district attorney and or representative is on the scene, and they have the authority to send out grand jury subpoenas, especially when they don't know the cause of death. And that was, that happens often. So it would not limit, this ordinance would not in any way, shape, or form limit their ability to act or not act. It would just be a matter of coordination and what we want as a city.
So we would be able to coordinate with the DA the timing of the subpoenas, what you're saying?
I don't know that. I don't necessarily know that. So there's 3 scenarios. There's 1, the district attorney's office can send out the subpoenas that they want. There's 2, we turn over information to them immediately, right? And then there's 3, the scenario we're talking about. We wait a specific amount of time and deal with that. So it would be a head nod in coordination, but not a mandate. And so we have a pretty good working relationship with other law enforcement, but it's going to depend on the circumstances, you all. And I also want to address Mr. Carroll asked this question, the witness issue. So there's two different schools of thought on that and going through this scale of litigation. Mr. Linder said, you got to be careful what you say in public. So that depends on whether or not the city council gets named in litigation, because, you're the policymaking board, and that's legislative policy, but still, most of the time people don't make the distinction. And I've seen that many, many times where you all have been named in a lawsuit, and ultimately Mr. Linder's predecessor and I would have to defend. And so we don't know what's going to happen. So out of an abundance of caution, we give you advice to make sure that you're staying on the straight and narrow. And all we can do, Mr. Linder and I can do, is give you all the legal advice. You all will make the decisions policy-wise that you all want to make, whether you can or can't do it.
So we can set a constraint on timing. We just don't know whether or not the DA or would subpoena the information quicker than our constraint.
You set a constraint on timing for the documents that's to the citizens.
Okay. All right. And then it would come down to how much time that we should allow, because we have a responsibility to the city also. I don't think 30 days would be, it would be too big, I would guess, in my mind. It would have to be an allowable amount of time. And I think that we as a council could probably come up with that to get that. The other thing is that the way the ordinance is structured, and Mike, I've mentioned this to you before, there are no absolutes. It's broad. There's no we shalls in here, or the city shall, or, other than that. Do we need to make the language in here definitive? Because yeah.
Well, there are several shalls. It says the ordinance says it's currently this doesn't have any kind of time limit like we're just talking about, but as currently proposed, it reads, for purposes of law enforcement agency recordings within the meaning of the state statute, it shall be the policy of the city of Mobile that any such recordings made by or in the custody of the Mobile Police Department shall be disclosed in response to any properly made request, unless contrary to other applicable law. So, I mean, if you'll forgive me, I think it's about as shall as it can get.
So are we saying that the shall, saying that the shall is directed towards any stakeholder? Is that what we're saying here?
I would answer in the affirmative. So yes, because you're conveying the right to the citizens. So we worked together to try to make this work. Mr. Linder had a really tough job in three things. One, he had to make this compliant with the state law. And then two, he had to make it comply with our current ordinance. And then most importantly, I think you got to remember, and I think Mr. Carroll brought out a good point. He asked the age of the current ordinance, which is 1979. Well, post 1985, we start to operate under Zogby. And so he has to thread that needle to make sure that it complies with all three of those. And then this goes back to something Ms. Gregory was saying, is our current policy is in alignment with state law. But what this does is it drills down into this at the local level, allowing those stakeholders to get some access and a response. So it's a mandate dealing with the citizens, but not necessarily so much of a constraint that it would run awry of state law. So if those grand jury subpoenas come out, then we're at a loss, but we still have to give people a written response and explain to them what's happening. So that mandates another level of communication, because a citizen, or a stakeholder rather, is entitled to that.
You keep mentioning Zogby. What section of Zogby does this fall under?
So there are two sections that are pertinent. You got 1144C21, which is powers of the council, and then 1144C37, which is the powers of the mayor. And so one of the things that you always have to think about is, in terms of that 1979 ordinance, Zogby didn't exist at that time. So the council is completely the governing body and in charge of legislative policy, but all executive authority is vested with the mayor by state law, not something we can change here in Mobile. That's a Montgomery discussion. But once again, Mr. Linder has threaded the needle to make sure that we tighten this up with shalls, and it gives us a level of responsiveness to stakeholders. And I have no opposition to adding a timeline to it, because that just gives us more of a guide into what we're going to do or not do based on the state law, the ordinances, and exactly.
Well, it keeps the door open for the opportunity for the major stakeholders in it. The 1979 law, the Zogby Act was truly about the formation of the council and the mayor form of government, but not for police action and policy and law enforcement. So why does Zogby trump the 79 law?
I've been waiting 10 years for somebody to answer that question. So there's this, when you're dealing with laws, there's the United States Constitution, there's the treaties, there's federal law, there's state law, and then ordinances fall at the very bottom.
Mm-hmm.
And so, to your point, state law is always going to override an ordinance, and that ordinance it always has to be subject to the state law. And so, if it falls in conflict, neither the mayor nor the council has vested powers to disagree or disregard state law. So Zogby is going to supersede every single ordinance that we pass. Every single one. State law is always going to the extent they're in conflict. That's right. That's right. And so you are vested with extremely broad powers when it comes to the legislative policy. And so I think all too often we're a bit myopic about what the council can and can't do, because we're looking at government plaza and city employees, whereas you all's vast authority is over the entire city and all of the citizens. So you can convey that right on the citizens without demanding some teeny tiny policy change at the department level.
The 79 ordinance, is that state law or is that municipal ordinance, Linda? It's municipal ordinance.
Yes. And that's why.
So in essence, the 79 law you can't merge it with Zogby without changing state law, but we need to make it a little bit more current.
I'm looking for it. I may be mistaken, but I think the Zogby Act specified that all ordinances that were in effect at the time of it were continued in force.
Well, if they're continued in force, then the conflict of a third party being able to view the body cams, it's a very real answer, and a third party should be able to view those, so that if there was a proper understanding to the general public, and we should be able to say if there's a true third party assigned and agreed upon that they need to be doing this. And we missed that, and we did not enforce that. So we need to make sure that we get that structure and that realization into our policies so that we're doing that going forward. Well, in essence, the ordinance says that it's already possible and it should be done according to the 1979 ordinance. So it's not like we're mandating, it's already a law, so we should be following the law. And we, at this point in time, we didn't take advantage of the law. Okay, so let's make sure that is in there solidly, that section, so we know that we can use that in the future. The policy on body cams, I'm probably going to want to hear a lot more from everybody else before I really ask a few more questions on that and the structure of the ordinance and the way it goes, because I want to hear everybody's position on releasing body camera footage. It seems like in some incidents we release it, in some incidents we don't. And the reason why I'm saying that is because of what happened with the 16, 17-year-old girl. Seems like that body camera body cam footage was all over the news.
Was that body cam or was that
That
was,
what was that?
that was somebody else's
Oh,
camera?
that was third party. I thought that was body cam from someone else, another officer. Okay, all right. Well, still yet, there's other body cam footage that's out there from other incidents that's in the public that goes out. I mean, I'll send you a couple of reels that somebody sent me over the weekend and this week, so y'all see what I'm talking about. If those are going out, then I think we just resolved that question with the third party.
Let's take a little time
or
out
s-
here because I see a lot of furrowed brows out there about body cam footage being out in the public. So Rob, Ricardo, is what he's talking about, is that footage from somebody's camera or
I'll
is
send
it
it
body
to
cam footage?
So we would have to be specific, case by case basis on body cam. I think what most people probably don't understand, we don't release body cam to the general public, and we have thousands of hours of it. I mean, every officer
Right.
in
Well, that was the
uniform-
question. Is it body cam footage from a police officer or is this a camera phone that somebody happened to have and they released the video?
The instance he just talked about was a cell phone, but he may have other body cam.
Yeah, I have
I
others from
just-
across the state.
I could tell you that's not something that we would release, except for, once again, our policy and state law. Even before state law, our policy allows us to give it to a stakeholder who's involved in litigation. So, for instance, every criminal defense attorney who asks us for discovery and body cam, we try to produce it to them, and that's a constant thing. I mean, it's all the time. So we're giving that information out on a regular basis, but only to the lawyer and the stakeholder. And so body cam is very closely held. And I'm not saying there's no instance where it doesn't go out, but I'm telling you that is not our practice. It's not our policy. It's not our procedure.
Well, I said one, but I'm seeing 4 or 5 others, and they're from everywhere, and how the state is handling this in other places. So, I mean, state law is state law. So what other cities are doing is, I think we should be parallel with other cities. So, I mean, if they can do it, then I think that there has to be some type of parameter for us to do it too. And like I said, I mean, Ricardo, I've got a lot here I can go through, with what I've discussed with Linda and the other things that I think should be in this ordinance. But I don't want to eat up a whole hour because I can. But I'd like to hear from what everybody else has to say before we get down the road on this, before I continue to ask a bunch of questions. But these first 2 things, Michael, I definitely want those in there. Third party, timing, those things from 1979, I definitely want those accounted for.
Let me just make sure I understand you 100% here. So you want, whether this or some other amendment to an ordinance, you want the waiting period for submission to grand jury.
Right.
And you want something involving an outside third party being able to review for purposes of.
Right. And it needs to follow the 1979 ordinance so that we're not reinventing the wheel. From what I was told by people that were involved during those times, some of the same incidences that were happening from the late 60s all the way up into the 80s are happening right now in this time period. And I'm not blaming law enforcement, but we're faced with some of the same challenging issues. And those laws right now also help direct and help us with some of these same challenging issues. And they need to be within our preview to be able to be used. So yes.
All right, we'll look for some wording on those amendments as well as any other questions that the council might have on the specifics and whether you can
Ms. Gregory,
do
I think
something like that. Yeah, Michael?
I think we can use some of the 1979 language.
That's what Michael is going to look at, Mr. Carroll. If you would let me go forward with Mr. Linder, appreciate it.
Well, I'm just going to say what the 79 ordinance contemplates is that there's an agreement between the police department and or the city with some. So I mean, I don't think we can just create a third party body or something out of whole cloth. It would have to be done, I would think, in cooperation. There'd have to be some kind of agreement between the city and this
I-
outside party or whatever.
I'm in agreement with that. I mean, in the past, I think it may have been the NAACP or the SCLC or someone
I'll
like,
tell you what,
or
because
someone
we
like
haven't
that.
got all afternoon, how about Michael and Ricardo and William too, if you want to get involved, y'all talk about it. Let's figure out what can and cannot be done and put that into an amendment, and we'll take a look at it. All right, Ben?
Under what circumstance would footage be released publicly? Based on what I hear from the state law, there is no circumstance by which it could be released publicly. Is that correct?
As far as I'm aware, yes.
Only way that it would be seen out in public is through some proceeding in the court, correct?
Yes, I think that's correct.
Okay. Section 4645 that deals with the non-conviction data, isn't it in direct conflict with this state law that we're reading from here, say item 1 through 6? Is this it? No. Is it not in conflict with this right here? The only in the custodial law enforcement agency may only disclose a recording to the following. Not any of the things that have been read in this 4645. It says 1 through 6, an individual whose image or voice is a subject, a personal representative of an adult, personal representative of a minor, personal representative of an adult individual under lawful guardianship, a personal representative of an adult individual who is incapacitated, a personal representative of a deceased individual whose image or voice is subject of the recording. Isn't that in direct conflict with this 4645 1979 law? That if this says this is the only circumstance by which it can be released to someone, and that says by some other arrangement through the police department or whatever, isn't that in conflict with this?
You can definitely make that argument. I think when you read the whole law enforcement agency recording statute on its own, it specifically carves out that, for example, that doesn't apply to the Alabama Rules of Civil Procedure, meaning litigation process, subpoenas, things of that nature. And again, there's some interesting verbiage in their definitions. Disclose under the state statute says this term does not include the release of a recording. So I think there's some room for the council to make policy regarding release of a recording outside of this. But again, it's also, I mean, again, it's one of those things, this is a pretty close question. It could be read, this entire statutory regime is saying this is the only way outside of the litigation process we deal with basically body cam or dash cam law enforcement agency footage. I wish I could give you a simple answer to that. It's complicated.
So there's a difference in definition between disclosure and release. Okay, so I need to.
The
read
state
into that.
statute defines disclosure at 210 subsection 4 and notes that disclosure does not include the release of a recording. The state statute goes on to define release in subsection 7 to provide a copy of the recording, but then does not use the term release again anywhere in the statute.
So not just this statute, but in any statute, does it deal with release to the public? You know, the general broad release.
Again, I can see it two ways. This does not talk about general release of footage, and therefore that power may be left to the council. But again, reading this whole statutory regime, I kind of, for lack of a better term, get the impression that the legislature's intent was to make body cam and dash cam and law enforcement recordings like that subject to this disclosure procedure, and this one only outside of the litigation process. Now, you could still make an argument there that because again, it carves out, you can share these with other law enforcement agencies and for purpose of investigation and other. That's kind of what our 79 Act says also. And in concert with, I think there'd probably be legislative room for some kind of additional release or disclosure of the footage. But in terms of an individual or a stakeholder requesting it, this state statute is the only way they can get it.
And that means basically with the body cam footage, that would mean handing them the video, not viewing it, but handing them the video. Is that what that would mean in this case?
Yeah, I think in some other situation, you would actually be handing a copy for analytical or statistical purposes or to ensure quality control or things of that nature.
Yeah.
But again, in terms of an individual who's subject to an encounter with law enforcement or a stakeholder, meaning their attorney or their guardian or something like that, this state statute is the only way they get to see the footage. Otherwise, it would have to be disclosed pursuant to a general policy, not a case by case. I would never advise the council to get into the business of mandating, we're going to release the footage in this case. That steps perilously close to violating Zogby, thereby actually involving you in a discrete individual matter and not making general policy.
Right. And Ben, I hate to interrupt, but what we're looking at in this proposed ordinance is viewing, not releasing to the general public as a whole, correct?
Correct. This doesn't even contemplate release to the individual involved, let alone the general public.
Okay, sorry. Ben, go ahead.
We have the authority as a city council to further restrict the state law as it's written, though, correct?
I'm not sure what you mean. For example, we could, if we went 180 degrees the other way, we could write a city ordinance that says, hey, you know what? You can, even if you're entitled under the state law to request this, we're never giving it out, period.
Okay,
You can't even see it. I mean, we would have the discretion to do that as well.
okay. I'm trying to get to the privacy issue with it as well, that if there was mutual agreement amongst parties, say a single person interaction, say it's me or you, and the state or government agrees to have it released and that party who is affected agrees to have it released, could it then therefore be released?
You're asking if the individual under that and I guess the city or the police department or the administration agree, can it be released?
Yeah.
I don't see a mechanism for that.
All right, Corey?
Thank you. I guess kind of talked about some of my concerns already. I agree with Councilman Carroll. I think that's very vital about some of the things he stated. Just want to get some clarity. So from a state legislative side, they do not allow for it to show body cams to be showed publicly, to
As
be
far-
released.
As far as the law stands right now, yes.
So no municipality is showing their body cam publicly right now.
They're not supposed to, other than through that state statute or, I mean, again, it wouldn't be public. They can show it to other law enforcement agencies for purposes of an investigation or something. They can give copies for that purpose if it's relevant to a larger criminal investigation. But in terms of, there is no public display of any of this provided for under the law right now. Yeah, again, the individual who has an encounter with the police is entitled to, and under our ordinance would be entitled to disclosure of it, meaning they get to see it. Or if you're a stakeholder, again, like the guardian lawyer or something like that, then you're entitled to see it. And then if you go on to if you do go on into litigation, they will get a copy of it at that point. That's going to happen in terms of a lawsuit.
Okay, so is that the way that it's being shown is when they get the copy and then is again showed to the public after that?
Well, no, again, it's any given individual or stakeholder who requests to see it under this state law. Basically, they make maybe if Ricardo might know the granular detail better, but for lack of a better term, they make an appointment to go view it.
He's talking about if it's produced as part of the lawsuit.
If it's not subject to a protective order, an order of the court or something at the point that it's admitted into evidence, or possibly even into the possession of the parties for evidentiary purposes, it very often becomes public at that point, yes. Depending on whether the parties involved want to release it and depending on whether they can. But again, if it's not subject to a court order or something requiring it to be held tight, at that point, it can be disclosed publicly.
So in addition to what Mr. Linder's saying is you have to think about all of these things in total. They don't operate in a vacuum. They just really don't. So the body cam statute for the state is fairly new, but what makes it somewhat more manageable for us is because it's not terribly different from the policy we were operating under beforehand. And then to Mr. Linder's point about litigation, it's twofold. One, we're not allowed to just put information out there, pieces of evidence out there, once we know litigation is imminent. And then 9 times out of 10, there is going to be a protective order on most of the evidence so that you don't poison the jury pool. And we have to adhere to that. So knowing what we know about a number of these incidents, especially if there's a claim on file, we take that into consideration. But I want to step back to how narrowly tailored this particular ordinance is and how careful we have to be not to trip over the existing laws. I mean, Mr. Reynolds brought up a great point of what's in conflict. But remember, the guiding light for us is not only state law, but what you all have on the books that could exist. We can't adopt something that conflicts with either one of those for fear that, one, it may be void. And then 2, I think Mr. Linder's done a fantastic job of keeping everybody on the right side of the law and not passing something that's no good.
So right now, it's no municipality in the state of Alabama that releases body cam.
I don't know that. I don't know that because, what people have sent me has not necessarily been body cam. I don't know that they aren't releasing it, but I can tell you this. You have to think about when. So we ask these broad questions without descending into the particular, right? This law is fairly new. It would not have covered what was happening before the law went into effect, right? So people would have probably released body cam then, and maybe they don't read it as conservatively as we might because they don't necessarily have the constraints and the privacy concerns in an ordinance and are not necessarily looking at the state law in context of everything else that's going on. So
I request that we see what other municipalities, Huntsville, Birmingham, Montgomery, what they're doing right now regarding body cam footage, and are they releasing their body cam footage?
I think that's more information never hurt us in the discussion.
Okay. Also, regarding this 4655 ordinance, would it override the 1979 ordinance? Because it seemed like it's
Ask that question again.
like the ordinance right here.
Yes.
Because we
This one that we're looking at.
that we're looking at.
So that short answer is yes, it work in concert, but anytime you update an ordinance, the ordinance that you're dealing with is the one that's going to be in place. However, there's only certain parts of it that are changing. You're not changing everything. Certain parts of 1979 you might keep as long as they don't conflict with current state law. They don't conflict with Zogby or the body cam law. They're going to be fine. But you have to thread that needle and be careful about that. Access is totally different from a mandate.
Thank you.
Joel?
I have a question for Mr. Linder. And it for my simple mind, it helps me to take a possible situation and understand how this particular ordinance is. Okay? So let's say we have an incident and the police department makes a determination that that there's nothing to investigate.
Hey, turn on your microphone, Joel.
What happened to it? Let's say we have an incident, the police department makes a determination that there's nothing to investigate. The cause of death is clear, what happened is clear, and all that kind of thing. And so and the district attorney doesn't think there's any reason to investigate. So under those circumstances, under this particular ordinance, the individual himself or his representatives could ask to see the body cam footage.
That's exactly right. They could ask to see the body cam footage, and if the grand jury was not an impediment or anything like that, they were entitled to see it at that point.
Now, let's take a different situation. Let's say we have an incident and the police department determines that there are some issues, okay? And they begin an investigation of the incident. The way I read this, under those circumstances, the footage would not be eligible for viewing by the individuals involved or their representatives.
I would say that if the police department has determined that that footage is part of an active law enforcement investigation, at least until the conclusion of that investigation, it can be withheld. They just have to
Right.
basically give them a statement. This is part of an active and criminal investigation, cannot be disclosed at this time.
Okay, and then they could reach the end of that investigation and decide that there was nothing further to investigate. And the district attorney concurs, and the individual or the representatives get to view the footage.
I would contemplate that everyone would be entitled to disclosure eventually. If not immediately, then once any criminal.
Trying to get the sequence of events.
Right.
On the other hand, the investigation could continue. They could pass it on turn it over to the district attorney and the Department of Justice, and all these investigations are going on, in which case you'd have to wait until the end of those investigations to allow the family to view it.
I don't think we'd have to wait for a Department of Justice investigation unless there were a court order or something. Yeah.
Right, you're right. So I'm kind of confused about this idea that about the time limit being imposed, because when this first came along, the way I viewed it was there needed to be a certain amount of time after the incident for the police department and the district attorney, if necessary, to determine that there was something to investigate or there wasn't something to investigate. And but now, if I'm hearing it right, the idea is, no, it's going to be the reverse. We're going to hold off making a determination as to whether there's something to investigate until an opportunity to view the material is extended to the individual or the representatives of the individual.
Again, if Ricardo wants to speak to this, he's welcome.
I'll just say this: if that's the intent, then why even have this anyway?
Well-
Why not just say? The individual, the family, or the representatives can view the material.
Well, no, I think what we discussed was because the active criminal investigation thing, that's 99 times out of 100, that's going to come down almost instantly. Whereas what we're talking about on the time period is my understanding. Again, Ricardo knows this in more granular detail, but it's been the city policy where you have an incident like we've been talking about, that they self-report both to the district attorney and the Department of Justice immediately. Right. What we would be proposing, and again, correct me if I'm wrong, Mr. Woods, but what I think we're proposing is, at least as to reporting it to the district attorney and the grand jury for their consideration separately, we hold off for a period of time so that the grand jury secrecy bar doesn't come down immediately. With our recent incidents on this, it's come down immediately because the city self-reported more or less instantaneously both to the district attorney and to the Department of Justice.
But let's say we did that. But if the police department was still conducting their own internal investigation, then the footage would not be available to be viewed.
If it were part of an active criminal investigation, yes.
Okay, I just got
not necessarily an internal.
To see this language y'all come up with.
Not necessarily an internal affairs review, perhaps, but if it's but there's a law enforcement investigatory privilege which is designed by policy to make sure that people don't start trying to subpoena or request materials that are actually in a pending criminal investigation.
So spot on. We have to be consistent with the other state laws that exist, and we have to be consistent when we're responding to people. We can't have a stakeholder have one answer in one situation and another in a different situation, because routinely We're trying to have these 3-tier investigations going on: the criminal investigation at the local level, the district attorney's office, and of course DOJ when we self-report. And all 3 of those are going on parallel. Sometimes they go faster than one another, but all of those under the current statute and other existing laws allow that privilege. And you don't put that information out there because you really don't know the outcome, and it could disturb the integrity of the investigation
Right.
in a number of ways, or put the grand jury pool in a compromising situation. So our goal was to be consistent, but also have some level of vision and clarity for the stakeholders who come to us prior to handing it off to the DA.
Right. I think this whole issue is a very complicated issue with a lot of nuances to it. And I think I'm in favor of moving ahead with particularly what's in front of us. But there are a lot of different, first of all, we have to, as you have pointed out, and Mr. Linder has pointed out, we got a lot of different statutes and ordinances to wind our way through and make sure we don't run afoul of any of them. And then secondly, and equally as important, is to make sure that as much as possible, everybody involved in one of these incidences is treated fairly and openly, and that the public's interest in the proper and correct administration of justice is served. So I think it's one of these issues, and you run across them every now and then, where there appears to be a simple, pat response, but the deeper you dig into it, the more difficult and complicated it becomes.
I agree.
This is on my mind, 2 things. Civil case without, a constraint issued by a judge, that's public record, correct?
Depends. It depends on who has access to it. So lawyers, we're not allowed under the rules of professional conduct. There's certain things we're not allowed to say in the general public, and we're definitely not allowed to try our cases in the public once litigation ensues.
I mean, if there was the body cam footage was used in a civil case, as long as there was no constraint issued by the judge saying this, you can't show this, it would be a part of public record, right?
Depends on where it is. If it's so, for instance, if it's municipal is not civil, I'm sorry. But if you're looking at state court versus federal court, depends on the standing order. So most of the time, if there's no order, no, it could be just pushed out there. But typically there's going to be an order that comes down, because these types of cases are very complicated and very controversial. So we also have standing orders.
Also, if it were actually used as evidence at trial, again, unless there's a specific order otherwise, then at that point it would be public record, and civil or criminal, yes.
The other thing is, as this ordinance is written, it is very broad. It says a written statement, and this is in section B, a written statement identifying the legal reasons for non-disclosure shall be given to the applicant. I think we need to define the applicant, who is entitled to see it in this ordinance. So, I mean, it could say anybody be an applicant, anybody who,
It's got to be one of the stakeholders.
right, I understand.
I agree with your point.
Yeah, I understand that, right? That's how the discussion's been around about this definition of stakeholder, and it may refer to it back in this Alabama code section.
I think the most precise way to do that would be maybe if instead of saying the applicant, we could say those persons identified in Alabama Code Section 36-21-212C1 through 6.
That's it, because otherwise it create an administrative problem with the volume.
I think that's a separate issue, Councilman Carroll. I honestly, looking at, and again, Councilman Davis was very right. The more you dig down onto this, the more things come into play and it gets complicated. But I honestly don't think, pursuant to the ordinance we have in place, if the police department had an agreement for purposes of, for example, quality assurance or something like that that we've been talking about, or with an outside party who reviews things, I'm not sure, subject to our existing law, that comes within this, because you're not disclosing it at the request of an individual. You're disclosing it pursuant to law and a properly made agreement between the municipality and an outside agency.
What does that do to the 79 ordinance?
I think it leaves those provisions in place.
So they're still usable.
That would be my opinion, yes.
Okay, I got a question on that. And this would be an amendment that we would have to really discuss further before we know. Let's just say this third-party entity was in place and they had a contract or an agreement with the police department to review this footage. They're not bound by any court order. They're not bound by any, duty to not release it themselves. If it is released to this party, there's nothing that creates a duty for them not to go on and release it.
I think you're getting the term view and release mixed up. To go in and see the evidence means to see it and not to view it. That's right. And not take it away from the police department. I have no intent of letting somebody walk out of the door with a video. I think you got to get the definitions correct. Everybody in your head right now. I mean, I've had a chance to read through this for a week or two now, but to view it and to actually see the evidence and be able to report back and saying, hey, this was proper procedure based on what we've seen, helps the community with having someone out there other than the family. Okay.
But the citizens community is not one of the groups of people that are entitled to view it under the statute.
We're
Isn't
not
that
saying
correct?
we're not saying a citizen community group. We're saying a group that's been authorized or pre-authorized by the police department. And we've had a group that's done that in the past, as I was reminded for the last 2 weeks by people a whole lot older than me that had to live through this quite a few times in this city. And I think that we should be able to take advantage of
But
that.
the past was before the body cam statute was passed.
I understand that, but
And
this
my-
is
my
just another
understanding-
source of
my
information.
understanding is that this group, whoever these people are, whether they're citizens or whoever they are, they're not one of these classes that are authorized to view it under the statute. Is that correct, Mr. Linder?
I think you can go both ways on that. If you read 36-21-212C, it says a custodial law enforcement agency may only disclose a recording to the following, and it's the 6 stakeholder classifications. But again, this law also defines disclose as not including the release of a recording. In other words, and then it defines release as to provide a copy of a recording.
Now, is that the state statute?
That is the state
It's a state
statute.
statute.
So you can make the argument, and again, I don't think a court would strike it down ultimately if under the provisions we have in the code and everything, and this was truly done confidentially and for quality assurance or community outreach where there was privacy protections, everything in place. I think a regime like that would stand up, but I could be wrong.
And Councilman, remember, I'm not saying that we let anybody come down here with the intent to cause malice or harm. I'm saying a responsible party where we know that we're going to have a legitimate viewing and a legitimate response, and somebody that's going to be responsible and responsive to the community. I'm not saying let's just go find Ned off the street and let him view it and run in and out of here. So you can't take that approach to it.
Ben, do you have anything else? Go ahead.
If I understood what Mr. Linder just said to Mr. Daves, was that under this ambiguity between a release and a viewing, it may be possible for an arrangement between the police department and some other third party to not let them view it, but to release it to them. Is that, did I?
Not release, view.
No, that's contrary to what I understood. That's what I'm trying to get to the bottom of here. According to this, the release definition and the viewing definition are different. And what I understood you to say to Mr. Daves is that under this statute, viewing is limited to only those 6 things. But because release is defined differently, there's the possibility that a release can happen between the police department and some cooperative arrangement of some third party. Is that the basis of the thought?
The state statute defines disclose or disclosure as to make a recording available for viewing or listening at a time and location chosen by the custodial law enforcement agency. This term does not include the release of a recording.
Okay.
That's how they define disclosure. Then if we go into this as a custodial law enforcement agency may only disclose a recording to the following, and it lists the stakeholders. There is an ambiguity about the difference between disclosure and release.
So it can.
And it does not go on then to use the term release anywhere else in
Maybe
the
it was
statute.
just a typo.
So 46, so going back to the 4645, 1979 ordinance that Mr. Carroll was discussing, in order for any of those or most of those to apply, there can only be a release, not a disclosure.
Disclosure, not a release.
I mean, the way the state statute defines disclosure is arranging a viewing for the stakeholder, whereas a release it considers to be providing an actual copy of the recording. So I would say there's room within the way our ordinances exist. Again, if an agreement can be reached between the city and some third party evaluator or quality assurance or something like that, to allow them to have a copy of it for purposes of analysis and review.
The release is the only way.
Well,
so-
you release it to them. You do not release it generally. There's nothing in the law that allows it just to be released to the public.
So we've got to
themselves.
be very careful with third parties who are not duty bound, to preserve and protect this.
Well, if they had entered into an agreement with the city or the police department, presumably they would be bound by the terms of the agreement. And I'm sure part of it would always be this shall not be disseminated out into the public.
Madam Chairman.
And would that also
we-
include their opinion as to what they saw?
Well, I
I
think that would be the purpose of it, is for them to review it and provide an opinion. It would only be that.
to some of the stakeholders.
But on whether just their opinion on that. Again, Councilman Carroll has said he believes there used to have been some mechanism like this. I'm not familiar with it. If somebody could bring that to me, I'd be very grateful.
Go ahead, Mr. Woods.
So two things, so we've read over this state law a number of times, and it strictly construes who we can disclose this to, right? And then there's this other, but doesn't talk about review. However, in a limited context, we can, or release, it can be released. We hire lawyers. We hire a third-party validator like Mr. Brown.
We just
or
did it.
the PM group. So that it contemplates being able to do that, but in a very closed setting. And I think we have to think about that, because I cannot go back to this enough. A great deal of time, what's caught on body cameras, after seeing tens of thousands of hours of it, is a victim or a witness on the worst day of their life, right? They're children. There are people who have been the victims of domestic abuse. There are people who have just lost a loved one, and they do not want to be put into the public circus for other people's entertainment. And I think that's part of, it's not so much looking at what we're dealing with the guilty. It's to protect the innocent and presumed innocent. And that's what even a criminal defendant has a right to be presumed innocent, and they should be. And you don't want to put that out there so that everybody condemns them and they don't get their day in court. And so all of these things, and like I said, my hat is off to Mr. Linder, because this is a very complicated issue, and he has threaded that needle and given you all a workable tool that works at the local level and gives you all a level of discretion to make legislative policy. The second point of it is of course, remember, as much access as we can give, we can't mandate what the DA's office does or what a judge does, or even in terms of these criminal investigations, this body is not able to mandate what MPD does in those confines, or any confines for that respect. But what we can do is convey a right upon our citizens, and more importantly, the citizens who are stakeholders, to be able to view this before it goes to a grand jury and that secrecy veil comes down?
Well, that goes to the timing, which as you and I've talked, you're amenable to it. I'm amenable to it. I hope this council is. But back to the third party, and you just mentioned it before I could get to this, the city has already taken this role with the hiring of Kenyon Brown, and so we're already doing it. So for those that are, in objection to this, I mean, it doesn't hurt us to put it down in writing to make sure that it's part of our policy, because we've already taken the steps to do it. I don't know why you're afraid to put it out there, so we're even more transparent now in doing it. There isn't a fight here. It's the right thing to do. I mean, it's our responsibility to be as transparent as possible and to have as much right information out there as possible to protect the public trust. And the more we fight against protecting the public trust, the bigger mess we make. The climate in this city is awful. It's awful. And the more we fight against protecting the public trust, the more we create a bigger mess.
Joel?
I object when Mr. Carroll gets up high on his soapbox.
I'm not up high on a soapbox. I'm telling the truth.
I
William?
object when Mr. Carroll gets up high on his soapbox and starts holding himself above everybody. We're here because we want to be as transparent as we possibly can and protect the rights of everybody involved, including the public.
Well, thank you, Mr. Davis. But I'm not on a soapbox. I'm only responding to what I think I hear coming from voices of the council, and I'm trying to help lead us in direction to where we have as much comfort with the citizens of the city in what we're doing as we are what we're doing. And the only way to get there is to make sure that we are all on one accord and understand that it's the public trust that we're trying to look out for the best. And I'm glad to hear you say that. But to do the things that I'm mentioning only makes it better for both the administration and this council and the law enforcement agency, because then public trust will be higher than what it is right now, and it makes everyone comfortable.
Ben, go ahead.
We'll just look at the amendment that you have, and then consider it that way. I don't think there's anybody fighting against
I
anything.
got you.
Mr. Woods, you got anything else?
I was going to say 30 days is probably a little long.
Well, no, it shouldn't be that long.
Yeah, it's
No,
just,
maybe a week,
yeah.
if that,
That's
or
what
a few days.
that's more
Right.
viable because
Right.
time is of the essence when we do
right. Maybe a week or a few days, but I'm not saying 30 days.
Well, I tell you what, since we have gotten, I think, a pretty good idea as to what amendments may be coming or that we might want to take a look at, Mr. Linder, I think you know what you need to do. So bring those back so that we can take a look at them. We appreciate everybody being here and working to make something happen. We all know that a change is in order, and I appreciate the administration for taking the lead, as well as President Small for putting this together so that we can do this. And I believe we are all here because we are all leaders and we all want to do what is right. And nobody is leading anybody's horse to water here. We are all doing what is the right thing to do and working together as a team, which we shall continue to do. Right, everybody? All right? I feel like the school marm trying to get everybody back on the same page here. Well, we're not off the tracks, but we all have a role to play in this, and no one person is going to be the leader to make one thing happen. We are all leaders. We're all going to work together to make this happen in the right way, correct? All right. Do I hear a motion to adjourn? Go ahead. You are the president, so go ahead.
This is being put off to December the 12th.
Is it the 12th, Lisa? Do you, what's gonna, 19th? Because we're meeting over at History Museum on the 19th. Is there time? I mean, what kind of time do you need?
The 12th, because you were supposed to not have meetings next week, so we push it to the week after that, which would be the 12th. I think you're right.
Yeah,
So
yeah.
Therefore, do we need a committee meeting next week? If you,
But when are you going to be gone, though?
no, I'm not. We're all going to be here.
Oh, nobody's going? Oh, okay. So we will, oh, yeah, okay. What do you think, Michael? Yeah,
I'll have something to you by next week.
okay, by like Monday? Yeah, CJ is asking, do we need another committee meeting
mean-
prior to this?
I mean, that's up to the council.
Well, it depends. Are you going to do what, 3 amendments, 2 amendments? What are you going
Madam Chairman.
to, and to what, I mean, will they be brief? Is it going to be like 3 or 4 pages of an amendment that we have to go through?
No, what I can do quickly, I believe, is this waiting period that we're talking about for grand jury submission. I can have that done easily by Monday, and then otherwise, what else were we contemplating? There's the thing about third-party validation,
Yeah.
but I would definitely want another committee meeting before something like that, because that's really that'd be invoking or amending another statute, and then there is the issue of whether or not, and then, I mean, there's the, I mean, again, the way the statutes are currently written, that'll have to be an agreement between the city and whatever third-party body we're talking about. And so that would, again, that involves more than the council. And as Mr. Woods said, if we change that statute, I believe it's valid on its own terms as it stands. If we change it in any significant way, then the issue becomes, does it comply with the Zogby Act now?
Question.
Go ahead.
I asked earlier if we leave it the way it is in the 79 ordinance, does that allow us to still use that law under the current statute?
Only to the extent it does not conflict with state law.
Okay, is there a direct conflict with state law in Zogby? Well, no, I'm talking about the allowance of a third-party review, not removal, but viewing of the evidence.
So that's a problem. I think it conflicts with state law, because that person has to fall within the confines of those 6 subcategories.
Well, the 79 statute states that it was allowable.
79 ordinance.
Or I'm sorry, 79 ordinance states that it is allowable. So, and you're telling me that 79 is still available.
Only to the extent it does not conflict with state law.
All right. Well, we're gonna need another committee meeting. We're gonna need another committee meeting.
Chair Latham.
In looking at the schedule, we'll just go ahead and call for another committee meeting next Tuesday, 12 o'clock. And whatever you've got ready, then we'll take a look at, and more discussion, I'm sure, to follow.
I'll also put in the amendment tying in the actual statutory definition and not saying applicant.
Right. All right, anybody else? All right, then we are adjourned.